Hello, my name is Layla Panzer,
I'm Elizabeth Robinson.
and for our business law presentation, we will be going over the Braunfeld versus Brown Supreme Court case. So our case introduction, this case relates to the conflict of attempting to conduct business on Sundays, even though Orthodox Jewish merchants were closed on Saturdays under their religious practices. And our overall question for this case is it a violation of the First and 14th Amendment rights to prohibit Jewish business owners from participating in commercial activity on Sundays? The parties relevant to this case, first we have the appellants. In this case, it was a group of Orthodox Jewish merchants, and they were led by Abraham Braunfeld. These merchants, they challenged the law as they owned a retail clothing and furniture store in Philadelphia, Pennsylvania. And they claimed that closing on Sunday would impair their ability for each of the appellants to earn a livelihood and continue their businesses. And therefore, the 1959 statute was unconstitutional. The appellee was David L. Brown, and he overall represented the Commonwealth of Pennsylvania. He defended the law and claimed that it was a secular regulation that was intended to promote a day of rest for all and reduce commercial noise, and it was not intended to promote Christianity or any major religion.
So the basic facts of the case are that it was argued in December of 1960, and the final verdict was presented in May of 1961. And the primary appellant in this case was Abraham Braunfeld. He owned a retail clothing and furniture store, and he was required, alongside his colleagues that were also Jewish Orthodox, to remain closed on Sundays under this Pennsylvania blue law. However, they needed to be open at least 6 days a week in order to succeed economically and keep up with their competitors who were not closing on Saturday to observe the Sabbath. So the appellant, Abraham Braunfeld, challenged this law on the grounds that it was discriminatory to those of the Jewish faith that were required to observe Sabbath from nightfall on Fridays until nightfall of the following Saturdays. And this quote comes directly from the case summary. It describes why they challenged the law. It says, due to the statute's compulsion to close on Sunday, appellants will suffer substantial economic loss to the benefit of their non-Sabbatarian competitors if appellants also continue their Sabbath observance by closing their businesses on Saturday. So for this case, there are three main sources of legal consideration. They all come from the Constitution. The first is the Establishment Clause in the First Amendment, which prohibits the government from establishing an official state religion or providing preferential treatment to one religion as opposed to the other. And specifically for this clause, there are three important criteria to consider when analyzing any law and determining if the clause has been violated. So firstly, the first criteria is that the law must have a secular legislative purpose. It cannot be inherently religious. Secondly, the principal effect can neither advance nor inhibit any particular religion. And finally, the law cannot foster an excessive entanglement of the government with any religion. Nextly, the free exercise clause ensures that all individuals have the right to practice their religion freely and they cannot be interfered with by the government. And finally, the equal protection clause ensures that all U.S. citizens are afforded equal considerations and protection under the law and that there are no instances of preferences. So applying the Establishment Clause to this case, we can consider whether there was an official religion established by the state and whether there were instances of government showing preference to certain religions over another. So firstly, in the case of establishing an official religion, it can be easily observed that there were no officials in Pennsylvania or in Washington that made a legal religion. They did not outlaw Jewish orthodoxy, nor did they make any other religion that of the state. So we can rule that out as being part of this case. And nextly, when determining whether or not governing officials showed favor to Christianity or any other prominent religions over Orthodoxy, it appears at first glance that this was the case because Sunday is observed as Sabbath by many Christians and those practicing other religions that don't have a Saturday Sabbath. And Pennsylvania blue laws do have Puritan roots. But After observing this case a little more closely, it can be observed that this law, the 1959 statute, was established only for the purpose of limiting commercial activity on Sundays. So it is still in accordance with the first criteria of the Establishment Clause, which states that laws must have only secular legislative purposes. And nextly, for the free exercise clause, we can consider whether or not the government purposefully interfered with religious practices, particularly of Jewish Orthodox Jews. So this can be observed in whether or not Abraham Braunfeld was able to keep his business open on Sundays, on Saturdays. He was able to close his business freely. He was not prevented by the government from doing this. So we can deduce that the government did not interfere with his religion in this way. And the conflict of compulsory closures on Sundays cannot be categorized as interference because even though it did inadvertently create economic difficulty for Abraham Braunfeld, that was not the primary purpose of the legislation because it was a secular law. So even though there were difficulties as a product of his religious observance, the observance was still possible and it was not prevented. And finally, in terms of the Equal Protection Clause, we can read this amendment and we can read this clause in the 14th Amendment because it was directly cited in the verdict of this case. So this says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So in the final verdict of the case, it was stated that the only question for consideration is whether the statute interferes with the free exercise of the appellant's religion. And this can be applied to the Equal Protection Clause in the 14th Amendment by determining whether or not this statute deprived Jewish Orthodox business owners of their property without the due process of law, since they were losing income on Sundays in addition to the Saturdays that they were required to observe by their religion. However, the purpose of this statute was simply to provide a day of rest to all people in common and to generally regulate commerce, which is indicative of equal treatment. Since all people were under the same law, it's not in violation of the Equal Protection Clause. And this quote comes also from the verdict. It says, "The Sunday law simply regulates a secular activity and, as applied to appellants, operates so as to make the practice of their religious beliefs more expensive."
All right, so now for the verdict. The U.S. Supreme Court held that the 1959 Pennsylvania statute preventing specified retail activity on Sundays overall did not violate the Equal Protection Clause of the 14th Amendment, warrant the establishment of new law protecting religion, nor did it prohibit the free exercise of the plaintiff's religion. So a quote from the verdict says that legislative power over mere opinion is forbidden, but it may reach people's actions when they are found to be in violation of important social duties or subservience of good order, even when the actions are demanded by one's religion. The court also stated, by such regulation, appellants contend the economic disadvantages imposed by the present system would be removed, and the state's interest in having all people rest one day would be satisfied. A number of states provide such an exemption, and this may well be the wiser solution to the problem, but our concern is not with the wisdom of legislation, but with its constitutional limitation. Thus, reason and experience teach that to permit the exemption might well undermine the state's goal of providing a day that, as best possible, eliminates the atmosphere of commercial noise and activity. So our reaction to this, we believe that it's pretty harsh and legalistic. We understand that the court claims they did not intend to discriminate anyone with different religions with this verdict, but the results did in fact discriminate Orthodox Jews. It unfairly burdened the Jewish business owners and forced them to lose 2 days of income instead of just one. We think that the court could have allowed an exemption to those that were already observing a religious Sabbath on an alternative day of the week, such as these Jewish merchants. They even mentioned that this was allowed in other states, so we think that they could have been more gracious and allowed an exemption to them as well. We also know that the court, their own acknowledgement that providing an exemption, quote, may be the wiser solution to the problem. We think that this shows that they were aware of the unfairness of the situation. The appellants share that in order to be as productive as other businesses, they would be required to ignore their religious Sabbath. Even though the law is claimed to be secular, it is very well known as a common Christian practice to be closed on Sundays, and a result of this statute forces that Christian practice of the Sabbath onto non-Christians, regardless of however the court may have advertised this as a uniform day of rest, commercial noise reduction, etc. However they advertised it, it still has the same effect. So even though legally it was found to be constitutional, the effects we believe were not. The court is prioritizing the city's commercial noise level over the economic prosperity of its own citizens and their ability to exercise their religion free of economic punishment. We also know that under the 14th Amendment, U.S. citizens are protected from being deprived of life, liberty, or property. In this case, if citizens voluntarily choose to work additional days of the week, we think that they should have the right to do so in pursuance of their property. And then here we have our bibliography and our works cited. That's all. Thank you very much for watching.